Good morning. Happy Friday. A couple people wanted me to talk about Glenn v. State, a Georgia Supreme Court decision. Some of them seem to believe that makes bad elk into good law. It does not. It was about a guy who was unlawfully arrested, and placed in the back of a police cruiser, damaged the police cruiser trying to get out. The original charge, he couldn't be charged with anything other than damaging a police vehicle, damaging police property, damaging community property, something like that. And the court ended up looking at it like it was self-defense. Now, in Georgia, you have a right to resist an unlawful arrest. You've always had that right. There has never been a time where you did not have that right. And it's not based on bad elk. It is based on English common law that was adopted by Georgia in 1776 and has not been abridged by the Georgia Senate or the Georgia Constitution ever since then. So there's case law in Georgia, from Georgia case law in Georgia that says you have the right to self-defense. Now, what the court did is the court kind of went down through a history of the common law right to self-defense. And they looked at various cases from various other jurisdictions. Like they looked at English common law cases, which obviously the Georgia State Supreme Court has no jurisdiction over, and they can't make an English case from the 1700s or even the 1800s into valid law. England has the right to do that, and only England has the right to do that. They looked at a case out of the colony of Boston, I believe, from 1709. Obviously, that has no bearing on anything because it was English common law at that time. So they can't make that into good law. And it's Boston, so they can't change what Massachusetts is going to do. So they can't make it into good law. Now, they also cited bad elk and diarrhea, which are two cases that I've gone over before. And they are constantly cited by people in federal court believing that they have the right to resist federal arrest. They do not. Nor does it confer on them a constitutional right, because both of those cases were based on common law. There is no more federal common law. At least they don't make common law anymore on things other than like things related to the Constitution, or on things that Congress has basically legislated on so they could make common law around it to fill in the gaps. But there is no longer a common law right to self-defense against unlawful arrest, federally speaking. There just isn't. Those are bad cases. They're still bad cases, and Georgia cannot make those federal Supreme Court cases into good law by citing them. All that the court in Georgia was doing was saying, look, here's a history of defense. Here's what other courts have stated around the common law right of self-defense. But the Georgia Supreme Court recognized and even went over that the Senate, the state assembly, whatever they call it in Georgia, and the Georgia Constitution can override a common law right to self-defense. And so they looked at the statutes and at the Constitution of Georgia, and they determined that nothing in those had explicitly overridden the right to self-defense. So all that case did was it extended the right to defend yourself against an unlawful arrest to the right to damage police property by trying to get out of a police cruiser if you have been unlawfully arrested and placed inside a police cruiser. It's not particularly novel, and it does not make bad elk good law. I hate to break this to you sovereign citizens out there, but bad elk is still bad law. Now, as I said earlier, Georgia has always had a common law right to resist an unlawful arrest. That doesn't make it a good idea, and I'm going to tell you why. Number one, if you go through that case, you'll see that there are very few cases that the Georgia State Supreme Court can cite from Georgia about the common law right to resist an unlawful arrest. And that's because normally there's probable cause when these things happen. And normally you get stuff down pretty hard because you got to prove that there was no probable cause. And the second thing is you can still die resisting an unlawful arrest. I want to point that out. You could die or you could get hurt. It doesn't change anything other than whether you go to court uninjured or injured and say that the arrest was wrongful. So I just want to make that clear. It's still a very bad idea to resist arrest. Now back to the probable cause thing. A lot of people seem to think that if you didn't do something, that there cannot be probable cause that you did it, but obviously there can. If a police officer walks into a room and sees you standing over a body with a bloody knife in your hand, your clothes are spattered with blood, and the person on the floor is obviously dead, the police officer would have probable cause that you killed that person. I mean, did you? I don't know. You could have walked into the room, saw the person with the knife in their chest, went down, pulled the knife out, which splattered blood on you, and tried to give them first aid to maybe save their life because you thought maybe they were still alive, which covered you with blood. And the officer comes in and sees you with the knife in your hand just as you've pulled it out. And, now you've been arrested for something that you didn't do. That's the way probable cause works. It doesn't matter whether you did or didn't do it. It matters whether or not the officer has reasonable articulable suspicion that you committed a crime, or that a crime was committed, and that you did it. I said reasonable articulable suspicion, which is the wrong standard. Probable cause, is probable cause. Here's all the facts in place. Dead body that with a knife in it, knife wound. That's probable cause that a murder was committed. And you standing there with the murder weapon in your hand, covered in blood, is probable cause that you did it. It just is. So just keep in mind that probable cause is different and distinct from whether or not you actually committed the crime. And indeed, some people have been found to have, they've been convicted of crimes, proven beyond a reasonable doubt that they committed a crime, when later on it turns out they didn't do it. So whether or not you actually committed a crime is completely different than whether or not the state can meet a particular standard, a burden of proof to suggest that you did. And speaking of probable cause, I want to go back to a video I made just recently where I talked about James Allen Springer, James Freeman, and his CPS video where he was arrested. In that, I said I couldn't find anything on the Arizona Supreme Court website where you could actually search through all the records. Well, apparently it was in a city court. It's in the Tucson Municipal Court. And they apparently don't share their records with the state. So Desert Sentinel was kind enough to give me a copy of it. And it turns out that James Allen Springer was indeed arrested on a misdemeanor disorderly conduct. And unfortunately, or fortunately, he was charged with probably the worst part of that for the officers to try to prove. He was charged with fighting words. He was charged with gestures or language that would tend to incite an immediate breach of the peace. Instead of being charged with making unreasonable noise or disrupting business. I forget what the other two sections were precisely, but there were a couple other sections that I'd said at the time that he might have been charged with. The reason why the charge wasn't good, in my opinion, for the disorderly conduct is because obviously he didn't say or do anything that tended to incite an immediate breach of the peace. Because instead of actually getting in a fight with them, they called the police, which is good proof that what he said or did not tend to incite immediate breach of the peace. So basically it comes down to the fighting words doctrine. And it's not a very solid case for the prosecutor to try to make. Now, James said that, number one, it was dropped almost immediately, and I guess that's a very relative term. He was charged with it on February 12th. The prosecution submitted a motion to dismiss it without prejudice, which means that they could refile it on March 26th, I believe. So a month and a half roughly after it was filed, which isn't immediate. And then James said that they didn't have probable cause. Now, there has been no judicial finding of probable cause, whether or not there was or was not probable cause. The prosecution filed a motion to dismiss without prejudice. My gut instinct says that James Freeman was arrested. They filed the wrong charges. Finally, an attorney who figured it out said, well, we really aren't going to be able to get him on this one, or it's going to be a very weak case to make, so it's not worth bringing it under this particular charge. So we're going to go ahead and file a motion to dismiss without prejudice, and then it's just not worth refiling to try to get him in there on a different charge. You got to remember, this was back when COVID was all the rage. The end of March, beginning of April. April was when we had the 15 days to slow the spread. That's a different video entirely, but you get my point. There were a lot of people being released. They weren't bringing a lot of misdemeanor charges at the time. James is being, I think, a bit optimistic that there was no probable cause. James is trying to craft a narrative that there was no probable cause. I don't know if there was probable cause. No one will know if there was probable cause until James Freeman files a lawsuit about the wrongful arrest. If James Freeman does that, and it goes all the way through to the conclusion of the civil trial on it, then maybe we'll know. But until then, James Freeman is talking out of his ass. Anyway, thanks for watching. Have a great Friday.